Good afternoon, everyone. My name is Faliti Kayoli from Ascent Litigation, and welcome to new section. And please don't forget to share, don't forget to like, and don't forget to comment. Basically, today we'll be talking about the power of the police to prosecute an action in the court. The power of the police to prosecute an action in the court. We all know that police is an executive arm of government. Police is an executive arm. It's one of the executive arms of government. And we all know that we have three arms of government. First executive arm of government that we have is the legislature. And secondly, we have the executive. And third, we have the judiciary. Basically today, we will be talking about police as part of the executive arms of government. Once if you are talking about the police is an executive arms of government that deals with the responsibility of preventing crimes. They deals with the responsibility of preventing crimes, and they also deals with the responsibility of preventing crime in the society. So basically, we all know that the police has the right to investigate crime. Now, the right and the power of police is actually provided in Police Act of 2012. It's provided in Part 7 of the Police Act of 2020. The Police Act, the Section 7, the Part 7 of the Police Act of 2020 give the responsibility of the police. It provides for the responsibility of the police, and the police has the power to investigate crime. The police has the right to arrest, and the police has the right to also complain and to report crime to Attorney General of the state and Attorney General of the Federation. And basically, if we are talking about the power of the police to prosecute, the power of Attorney General of the state to prosecute, if we are talking about the Attorney General of the Federation to produce, all is provided in Section 174 and Section 211 of the Constitution of the Federal Republic of Nigeria. And the power of the Attorney General of the Federation to prosecute, and the power of the Attorney General of the states to prosecute is also provided in Section 106 of the Administration of Criminal Justice Act. Basically, the Attorney General of the state and Attorney General of the Federation has the right to institute. They have the right to take over. They also have the right to discontinue a criminal matter. And basically, by virtue of Section 66, subsection 1 of the Police Act, also provide that a police officer who is a legal practitioner can also institute an action in the court. And basically, by virtue of the Police Act of 2004, only provides that only the police can institute an action or can prosecute an action in the court. But the enactment of this of the new law of the Police Act of 2020 has modified the provision that provide that only the police can prosecute an action. Now it is only the legal practitioner who is a police can institute an action in the court. And basically, after this, we all know that after the police has prosecuted an action in the court has the right, the police, has the right to inform the suspect that this is the particular offense that you have committed. This is the particular offense that you have committed. So it is the responsibility of the police to inform the suspect about the crime that he or she has committed. And basically, after this, the police also has the right to bring the person to the court at appropriate time. The police has the right to bring such a person to the court at appropriate time. If such a person is not actually bring to the court at the appropriate time, such a suspect can actually bring an action for his right because his right has been infringed. the right has been infringed, he can bring an action based on breach of fundamental right. And the court will take cognizance of the time that such an accused person has spent in the custody of the police. So these are these powers of the police. And we all know that the police has actually gone beyond their power. That is the main reason why we citizens of Nigeria needs to know about our rights. And all the rights are actually entrenched in the Constitution of Nigeria. And basically, once a person is being charged to the court, the police has the right to make sure that such a person actually defend himself or actually call a legal practitioner of his choice. We've seen a lot of cases whereby an accused person will come to the court without a legal practitioner, and the magistrate can sue motu actually informed the accused person that, do you want to defend yourself? And the magistrate will actually advise the accused person that you have the right to employ a legal practitioner of your choice. And basically, I told you that under section 66 subsection 1 of the Police Act has actually empowered that only the police officer who is a legal practitioner can prosecute an action in the court. And basically, we have to look at the provision of section 66 subsection 2 of the Police Act, which provides that a police officer who is not a lawyer can also prosecute an action in the court that is subject to the criminal procedure law of various states. So what we are trying to say is that we need to look at the provision of section 66 subsection 1 of the Police Act, which says that only the police officer who is a legal practitioner can institute an action or can prosecute an action in the court. That is the provision of the section 66 subsection 1 of the Police Act. That is, only the police officer who is a legal practitioner can bring an action in the court. But we can now see that section 66 subsection 2 has actually provided for the exception of section 61 the provision of section 66 subsection 2 has actually provided the exceptions in section 66 subsection 1 that a person who is not a lawyer, a person who is not a police officer who is not a lawyer can also bring an action, can also prosecute an action in the court, subject to the criminal procedure law of the state. So the question now is that who can bring an action, who can prosecute an action in the court. So the answer to it depends on the law of the state. Depends on the law of the state. Unlike Ogun State law actually provides, it actually gives the provision of Ogun State law provides that a police can also prosecute an action in the court, despite the fact that such a police is not a legal practitioner. But basically, anybody can institute an action in the court subject to the provisions of the law of the state. So that brings an end to the right of the powers of police to prosecute an action. And once again, don't forget to share, don't forget to like, and don't forget to comment. Once again, my name is Falisi Kayode, Ascent Law Counsel.